of power, which is appreciated.
You're very kind. I'm very much in favor of a peaceful transfer of power.
This conference will now be recorded.
We are live streaming and we are ready to start the meeting, Dr. Bechtel.
The time is 10:02 a.m. The January 13th, 2021 meeting of the State Medical Board will come to order with the following members present via video conference. Dr. Rothermel.
Present.
Dr. Safran.
Present.
Dr. Gaccaloni.
Here.
Dr. Soin.
Present.
Dr. Schottenstein.
Here.
Dr. Johnson.
Here.
Dr. Ganadakis.
Here.
Ms. Montgomery.
Here.
Dr. Feibel.
Here.
Dr. Reddy.
Present.
And myself, Dr. Bechtel, present. Do I hear a motion to approve the minutes of the December 9th, 2020 board meeting as drafted? Do I have a motion?
So moved.
Okay. Dr.
Second.
Dr. Schottenstein. Thank you. All in favor say aye.
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 The board will now consider the reports and recommendations appearing on today's agenda. Has each member of the board received, read, and considered the hearing record, the findings of fact, conclusions, and proposed orders, and any objections filed in the matters of Dr. Ava G. Davis, LMT, Dr. Frida J. Flynn, MD, Dr. Joseph Michael Franzese, MD, Dr. Angelman Sharma, MD, Dr. Aying Yechi Rose Rada, MD. Roll call. Dr. Rothermel.
Yes.
Dr. Safran.
Yes.
Dr. Giacalone.
Yes.
Dr. Soin.
Yes.
Dr. Schottenstein.
Yes.
Dr. Johnson.
Yes.
Dr. Cacarella.
Yes.
Mr. Ganadakis.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel. Dr. Feibel.
Yes. Yes.
Dr. Reddy.
Yes.
And Dr. Bechtel, yes. Further, does each member of the board understand the board's disciplinary guidelines do not limit any sanction to be imposed, and the range of sanctions available in each matter runs from dismissal to permanent revocation or permanent denial? Roll call, Dr. Rothermel.
Yes.
Dr. Safran.
Yes.
Dr. Giacalone, or Mr.
Yeah.
Giacalone? Okay.
I'll say Doctor, either one you like, Michael or Mark. Thanks.
Dr. Soin.
Yes.
Dr. Schottenstein.
Yes.
Dr. Johnson.
Yes.
Dr. Cacarella. Mr. Ganadakis.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Reddy.
Yes.
And yes, Dr. Bechtel. Does each board member understand that in each matter eligible for a fine, the board's fining guidelines allow for imposition of a range of civil penalties from no fine to the statutory maximum amount of $20,000? Roll call, Dr. Rothermel.
Yes.
Dr. Safran.
Yes.
Mr. Gaccalone.
Yes.
Dr. Soin.
Yes.
Dr. Schottenstein.
Yes.
Dr. Johnson.
Yes.
Dr. Cacarella. Mr. Ganadakis.
Yes.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Reddy.
Yes.
And yes, Dr. Bechtel. In accordance with the provision of Ohio Revised Code 4731.22 F2, specifying that no member of the board who supervises the investigation of a case shall participate in the further adjudication of the case, the secretary and supervising member must abstain from further participation in the adjudication of any disciplinary matters. In the disciplinary matters before the board today, Dr. Rothermel served as secretary and Dr. Safran served as supervising member. In addition, I, Dr. Bechtel, served as secretary and/or supervising member in the matter of Dr. Flynn. During these proceedings, no oral motions may be made by either party. Finally, the respondents and their attorneys addressing the board will be allotted 5 minutes to do so. The board parliamentarian will advise when the 5 minutes has expired. The assistant attorney generals will be subject to the same limitations. Please turn to the matter of Ava G. Davis, LMT. Objections have been filed and were previously distributed to board members. Mr. Porter was the hearing examiner. The matter is not disciplinary in nature, and therefore all board members may vote. A request to address the board has been filed on behalf of Ms. Davis. 5 minutes will be allowed to the address.
This is Attorney Hankey. Do you want me to speak on behalf of Ms. Davis at this point?
Yes, that would be. Thank you.
Thank you very kindly, and thank the board for allowing me to speak on behalf of Ms. The new House Bill 442, which was passed by the General Assembly and signed by Governor on, I think, January 7th of this year, is applicable to my client. She has presented evidence that she's 18 years of age and of good moral character, and she attained a high school graduation. More importantly, she has shown that she received her education, instruction, in massage therapy from the World of Beauty Academy in Orlando, Florida. And she became licensed to practice massage therapy in Florida on August 2019. And she completed approximately 800 hours. The problem with the previous law, statute versus the present provided that she needed 275 hours in anatomy, physiology, and pathology, and kinesiology. She did 290 hours versus the 275 hours that's now required. Formerly, it was 325 hours. And I refer you all to the transcript at pages 10, 22, 3, and States Exhibit 4. She has at least 325 clock hours of massage theory and practical, transcript at page 10, and she only needs 275 under the present law. She also has 25 hours in ethics and 25 hours in business and law. And accordingly, the student records, the remainder of the board's academic requirements have been met, and that's transcript at page 10, and that was in the report filed in this case. In summary, basically, the evidence shows that she has passed all the requirements presently that the law requires. She has 800 hours. The law now requires 600 total hours versus formerly 750. The law requires 275 hours in anatomy, physiology, and pathology versus formerly 325. She has 290. And regarding massage theory and practical, she has 325 hours versus the 275 hours now required. But when looking at everything, I think most importantly and significantly, the testimony of John Hoke, a retired airman in the United States Air Force and also a licensed massage therapist in Ohio. Formerly, he was licensed in North Carolina. Ava performed 2 massages at no pay on him. And he indicated she was as good as any massage therapist with whom he had worked. He says Ava knows the body, works the muscle groups well, and is very skillful. In fact, he had a problem with his right shoulder for years, and she was able to identify the problem and work on it skillfully. And I think very important, at least in this business, when you're dealing with the public, Ava is considerate and compassionate. And I hope when the board considers everything, it will see that she has passed all the requirements. Indeed, she passed the MBLEX test, and she, I think on August 20th of this year, she took an additional 12 hours of continuing massage therapy courses. Thank you all very kindly, and have a great day.
Thank you. Does the Attorney General wish to respond?
No, thank you.
Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Ms. Davis? Do I have a motion?
Moved.
Second?
Second, Dr. Caparella.
Do we have any discussion? Dr. Schonstein.
Hi, thank you. So, in fact, we are aware now that House Bill 442 was recently passed by the General Assembly, and it amended Section 4731.19 Ohio Revised Code with respect to massage therapy course of instruction. And the law will become effective sometime, probably early April 2021. I agree with defense counsel that the change in the law is potentially germane to Ms. Davis's case, but I do not think that we would be right to wave this through today. There are other concerns about this license application. I think the right thing is to remand the case back to the hearing unit so that they may take additional testimony to ascertain whether the application for licensure meets criteria under the new law. So I would actually like to make a motion to remand the matter involving Ms. Davis back to the hearing unit to take additional testimony or documentary evidence related to the statutory changes related to massage therapy course of instruction.
Second.
I'd like to have a vote on the substance of the amendment. I'd like to go through a roll call. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Dr. Gaccaloni,
Yes.
Dr. Soin,
Yes.
Dr. Schottenstein,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Gunadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Reddy,
Yes.
and yes, Dr. Bechtel. Before voting on the motion to,
I'm sorry, Dr. Bechtel. I'm sorry to interrupt. This is Benton. The board just approved the motion to remand, so actually we don't need to go any further than that.
okay,
As a remand, and we haven't done a remand for a long time, but the matter is now remanded back to the hearing unit per the motion, so we can move on to the next case. Although I think Mr. Giacconi has a question.
Mr. Gunadakis.
Oh, sorry.
May I ask a question, please? Mr. Hankey? When will I be notified regarding the new hearing for additional testimony?
Mr. Hankey, this is Kim Anderson. You will receive notification from the hearing unit. I don't know the exact date or time, but you will be receiving notification.
Thank you very kindly.
Dr. Bechtel.
Please turn, Mr. Gunadakis.
Yeah, thank you. As a follow-up question to defense counsel's question to Kim, practically speaking, what are we looking at from a timeline perspective from our end for this applicant now that we have remanded it?
I'm not sure. I think that's going to depend on this.
This school provided notarized transcripts of her training, 3 of them, and they were all different. It brings into question the veracity of the school, and I just think that needs to be ferreted out in addition to the law change that when this comes back to us, I will hope that would be ferreted out prior to coming back to us.
Thank you. Mr. Gaccaloni?
I echo Dr. Feibel's point, and that was the point I wanted to make. We have 3 transcripts that don't seem to jive here. We need to dig into that to at least try to verify what's going on here.
Any other comments? Thank you. Please turn the matter of Frida J. Flynn, MD. No objections were filed. Mr. Porter was the hearing examiner. A request to address has been filed by Dr. Flynn's on Dr. Flynn's behalf. However, the request was not filed within the board's established deadline for today's meeting. Therefore, the board will need to vote on this matter. Do I hear a motion to grant Dr. Flynn's request to address the board?
So moved.
Dr. Schonstein? Do I have a second? Second, Dr. Coccarella?
Second.
Okay, thank you. A motion was made and a second was confirmed, and so I'd like to take a roll call. Dr. Rothermill?
Abstain.
Dr. Safran?
Abstain.
Mr. Gaccaloni?
Yes.
Dr. Soin?
Yes.
Dr. Schonstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Mr. Gonadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
And Dr. Bechtel, I abstain. The motion is approved. Dr. Flynn may now address the board. You have 5 minutes that will be allowed to address the board. Dr. Flynn?
Can you hear?
Yes.
Are you able to hear me? Okay.
Yes.
Good. I don't have an extended speech. I just didn't do anything wrong. I was raised to trust policemen, and when my office was stormed by over 30 gun-carrying people at 7:30 in the morning, unexpectedly, I was just taken by surprise, and I thought at my age, I don't need to be doing controlled drugs. If, there's this much stress involved with it, there's plenty of other things I can do. And I just told him I didn't want to do any controlled substances again, not understanding, not asking for a lawyer, didn't thinking I need one. I just told him I didn't want to do those anymore. I could do plenty of other good things. Right now, I just put in my volunteer application at the University of Cincinnati to help them with blood gases and lumbar punctures, things that I'm good at doing that they may be needing help with. That's the only real reason I would like to continue to practice. I participated in a study a year ago and received the Moderna vaccine. I'm now immune, we hope. And so I would just like to continue to be of service. That's all I would like to say. Thank you.
Thank you, Dr. Flynn. Does the Attorney General wish to respond?
Good morning, board members. I'll just be very brief. As you can see from the report and recommendation, Dr. Flynn is under a current agreement with the board. She is on probation that was extended by a June 2019 order. For purposes of this hearing, we were there simply on the issue of whether or not there was a DEA surrender, which there was. We proved that there was. So I would ask that you ask yourselves as board members whether or not you feel that continuing Dr. Flynn on probation at this time is something that would be beneficial for public safety and for purposes of board resources. I would rely on your expertise to make that determination. Thank you.
Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Flynn? Do I have a motion?
So moved.
Dr. Schonstein? Dr. Safran, thank you. I will now entertain discussion concerning the matter of Dr. Flynn. Is there any discussion?
Did Dr. Safran second? Dr. Safran is recused.
It was Soy that second.
I
didn't say I'm sorry.
Okay. Sorry. Thank you.
Thank you.
Ms. Montgomery?
Yes, thank you so much, Dr. Bechtel. I was wondering if the board would consider us remanding this back to discuss whether or not Dr. Flynn has indicated that she is not going to be, that she is retired, that she is now working through trying to process her medical records for her patients, and rather than going through and doing a reprimand and doing these things, I think that there are, if we could remand it back for possible settlement discussions to the investigation unit and or the Attorney General to see if we have if we can get a surrender of the license because by virtue of retirement. It seems to be the more, I think, frankly, humane way of handling this. And so I guess my suggestion is to amend the proposal to seek a remand back to the investigations unit or the Attorney General for possible settlement discussions.
Any further discussion? Mr. Giacalone?
Actually, before there's further discussion, Ms. Montgomery made a motion, so we should see if there is a second to the motion to amend.
Okay.
I would second that.
Okay. Second.
And in particular, I think Dr. Flynn has a bit of a history with us, and I think if she's planning on a retirement, this would be a good opportunity to effectuate that retirement through the settlement process, as opposed to continuing this ongoing relationship we have with her.
So we need to now vote on the substance of the proposed amendment.
There should be more discussion, I think. If I'm not mistaken.
Yes, Dr. Feibel is asking to be recognized.
Yeah, I appreciate the idea behind it. However, I think that ship has sailed, and to burden our already overburdened hearing unit and everyone else with that, I don't think is the best use of resources. And I think Dr. Flynn could have done that to begin with. I am not comfortable with just a reprimand personally. And I think we should non-permanently revoke her license at this point. And she can still figure out her medical records in the meantime and do all that. And if she decides she wants to come back and practice, she needs to come back to this board. It's very concerning to me that 31, 41, however many armed DEA agents stormed her office and she immediately surrendered her DEA license. Most people don't do that unless they're worried about discovery of something. And I just am not comfortable with just a reprimand personally. And I feel that her license should be non-permanently revoked until more details can come out about what happened. She says she's not going to practice anyhow, so it really shouldn't affect her. And I don't think we should burden the hearing unit or the attorney generals with having to negotiate a settlement agreement in this case.
Dr. Stein?
Yes, hi, thank you. I don't support the remand order of sending it back to the board. I think, look, if you guys don't want this person in practice and you want to remand it so she can permanently surrender, just go ahead and revoke her now. I don't know why we'd remand it, go through that whole process, burden our staff to get an outcome that you guys want to get right now that you have the power to give her today. But on that note, I don't really mind reprimanding her and the order as is. She doesn't have a DEA license anymore. She won't be able to write controlled substances. And if you guys are worried about that issue from a public protection standpoint, I mean, that's, punishment enough, so to speak. And, she won't have the ability to do those types of things anymore. And I don't know if that necessarily puts her at risk to harming the public. I'm fine with the proposed order, but I'm also, fine with seeing what else everyone else wants to do. Other than I don't support remanding this back to the board to try to get an outcome when you can actually just get that outcome right now today.
Dr. Scheinstein.
Hi, thank you so much. I also do not support the remand. Dr. Flynn just got done telling us that she's inclined to, practice medicine on a voluntary basis. I'm guessing that if this is remanded and the option of a surrender of the license comes up, it probably won't be something that she would, be inclined toward. And it would not surprise me if that option was already offered. And so I also do not think the remand would be productive. I'm also in favor of the reprimand. I don't want to read too much into the raid without more information, because people make mistakes and government bodies make mistakes. And we don't right now have any evidence as to what provoked that raid. So until I do, I think that I'm just focusing my mind on the matter at hand, which is the surrender of the DEA. And I think that the reprimand is appropriate in that regard.
Mr. Caccoloni?
I appreciate everything said. Here's my 2 cents on this. Dr. Flynn has a history with us, and it continues and it continues. And honestly, I struggle with whether she should practice. That being said, I think it's at least if she understands that the alternative is if we remand it back, that it's probably going to get pushed for revocation, or permanent revocation, in fact. It gives her an out here to retire graciously. I don't like it, but I'm struggling with how we keep this practitioner in the situation that we do not right now. I don't know, but I hate the thought of having a revoker. I'd at least like to give her an option to graciously exit. But if the group is, the other way, I just really struggle with this practitioner, quite honestly, just because it's almost like we're on an ongoing basis with her. She's always here. And I don't know, that does not serve the public, quite honestly. But fine, if you want to take the hard road, I'll go there. I just prefer the remand, at least give her an exit strategy that at least somewhat benefits her. Maybe it doesn't. That's it. Thank you.
Just one other comment. First of all, whether we send her back or not, if we reprimand her, we're going to be dealing with her in probation. So we're going to be dealing with her one way or another. So it seemed to me, and I didn't want to comment on this publicly, but if you look at her history, we've got some mental health issues. And if you listen to the report, the hearing report, there's, first of all, you clearly seems that she has no understanding how important and how specialized treatment with regard to prescribing and the kind of work that Dr. Swain does. She doesn't seem to have any understanding or sophistication with regard to that. I don't mean to demean you, Dr. Flynn, but and there seems to be, I've been in that situation. I think I can understand what happened with the DEA. That's not necessary to comment right now, but and she hasn't filed her income taxes. We see a person who hasn't been able to put her arms around life's responsibilities. I only say this is a case that should have been, I think, settled without bringing it to the public, and she should not be practicing law. And frankly, under the new statute, even if she retired her license, or she has been the subject of, I believe I read the new law in a way that she would not be able to volunteer without a license, or have her license extended because she has this history. We'll be talking about that later. So that is the rationale behind me. I think we're going to be working with it one way or another. Where are we most effectively able to work with it? Are we going to continue to do probation and this kind of thing? Or do we want to just say, look, let's either see if we can negotiate a settlement where she retires her license permanently, or we do something more than a reprimand. I think that her whole outlook, her whole background screams a lack of understanding of the consequence of And I'm not the psychologist or psychiatrist here. So that is the only rationale behind it. I certainly believe that she needs to have discipline of some kind, but we shouldn't have her practicing. Is there another way to do this where we are no longer engaged with her effectively, and let her exit with some dignity given her background? So that's the only rationale. I'm not at all diminishing her practice problems, which seem to be enormous, and her lack of sophistication. Again, with all due respect, Dr. Flynn, your lack of understanding how critical the services that what was happening with your patients, and Dr. Sloan and others on this board are far more sophisticated and more knowledgeable about that than I. That's just the rationale.
Any other discussion? Then from a parliamentary question, do we move forward then with an amendment if somebody wants to make an amendment?
Well, currently there's a motion on the table to remand.
Yes.
So that would have to be dealt with first before, and if that fails, the board can consider amendments. And if it passes, then the case is concluded for today.
Okay. So I'd like to go and vote on the proposed amendment for remand, and I'd like to ask for a roll call. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Gacaloni?
Yes.
Dr. Sloan?
No.
Dr. Schonstein?
No.
Dr. Red? Dr. Johnson?
No.
Dr. Cacarella?
No.
Mr. Ganadakis?
No.
Ms. Montgomery?
Yes.
Dr. Feibel?
No.
And Dr. Bechtel abstain. Then do we have a vote count?
Yes, actually, can I ask, I didn't catch Dr. Reddy's vote. What was your vote on that, Dr. Reddy? No, thank you very much. That was 2 votes in favor and 7 against with 3 abstentions. The motion to remand does not pass.
Okay. So the amendment has failed.
I'd like to make a motion
Yes. Dr. Feibel?
that we non-permanently revoke license.
To make that clear, you said non-permanently revoke?
Correct.
Okay.
But she can come back and reapply.
Do I hear a second?
Dr. Cockrell, I'll second the motion.
Any discussion? Further discussion?
Again, everything I've heard, this is not, if this had been the first time she came before us, I would say I feel comfortable with it, not doing that. She says she doesn't want to practice. I think to allow her to practice at this point without coming back to us with a practice plan and what she's planning on doing and replying and everything along those lines is a really bad idea from a public protection. And I think a reprimand does not protect the public.
So we have a motion and a second on Dr. Feibel's proposed amendment, and I'd like to have a roll call. Dr. Rothermel?
I'm sorry, I believe Mr. Giacalone has the further discussion.
Okay, Mr.
Let me ask a practical question. I mean, we keep kicking this can. I mean, if we don't think she's qualified, why don't we just permanently revoke her? I guess starts to become my question, because, you know, we just keep doing this, and honestly, I don't see the value in continuing this process. If we don't think she's competent and capable, just to permanently revoke her. So I guess my question is, I'm going to put that up as an amendment and post it, because honestly, I feel like we are doing this half-baked. Do you think she's competent to keep going, or no? And again, she's got a history. It's not like this is the first time around. She's got a history with us. So I'll put that out for discussion.
Any further discussion? Dr. Swain.
Yeah, hi, and I appreciate that comment from Mr. Giacalone to that extent. I think, if you're an individual board member, that's really what you have to weigh. If you don't feel like she's fit to practice, I think a permanent revocation would likely be a better option than revoking. If you're making that decision that she's not fit, it make more logical sense to me to go for something like that. Again, I would still like to make a case for a reprimand on this particular physician. I totally understand everyone's concerns about repeated history at the board. But again, she already has her DEA certificate revoked. So it's not necessarily that this reprimand's the only thing that's happening. She will no longer have the ability to write controlled substances. And when we're looking at the substance of this particular R&R, that seems to be the breadth of the concern is, her prescribing patterns. And in the absence of her having the ability to do that, I think it's possible that she could perhaps, practice and contribute to society in ways where she wouldn't be restricted from harming the public because she no longer has a DEA certificate.
Dr. Schonstein.
Hi, I would echo those comments. I'm not sure that there's how shall I say, a good rationale for a non-permanent revocation. If the thought is that if the consensus of the board is that the doctor is not safe to practice, then it makes sense to permanently revoke. And I also still think the reprimand is reasonable for the reasons Dr. Soin mentioned. There's no DEA license. And again, the allegation on the table is the surrender of the license, right? So sticking strictly to that allegation, I think the order is appropriate.
Any other discussion? Mr. Kaplan?
I agree and I disagree with Dr. Johnson because this isn't in a vacuum. It isn't just this event that we're looking at, right? If it was just this event, that's one thing. We're looking at a compilation of issues here that have progressed over time. So that's where I struggle with how to make this a reprimand because this is beyond just that. This is a competency. As far as I'm concerned, there's a question of serious competency. I think this is kind of a bit of the tip of the iceberg of competency. It continues to progress and progress from a public health standpoint. I don't think the public is safe, quite honestly.
Dr. Feibel?
Along those lines, I have a hard time believing the story that knowing you're on probation already with the medical board, the DEA comes in, storms your place, that you just say, here's my DEA license and I'm done. The purpose of doing that is hoping that there's no investigation into this that clearly didn't happen once she surrendered her DEA, to pull back the covers and figure out why the DEA came in. She's already on probation. You can't look at this in a vacuum. The DEA does not storm offices for no reason. It's not a thing. And I just think the writing is on the wall here as far as the again, we're here for the public safety. We're not here for Dr. Flynn, and we want to make sure the public is safe. And I do not feel that Dr. Flynn continuing in practice, she is safe. The reason I went for a revocation, that I proposed a revocation, was because I certainly didn't think people were going to go for a permanent revocation if they if they feel the way they do and they just want to reprimand. That's why I said a revocation, and she could apply back here. I'd prefer a permanent revocation, obviously, but I didn't think there was any way this board, with the way the conversation was going, that they would ever support a permanent revocation. So again, my duty is to the public, and I worry with this fact pattern that it doesn't add up. Why you would just, a DEA person comes in and you say, here's my license right away. So don't investigate me. Here's my license. It just doesn't add up to rationality. And I don't believe it.
Well, I think we have a motion on the floor is from Dr. Feibel in regards to a non-permanent revocation. It's been seconded. I think the next step is to vote on Dr. Feibel's amendment.
We'll do that. I don't know if Dr. Cockrell will re-second, but I'm happy to propose the amendment, make it a permanent revocation if that is acceptable. If that would be more.
I would second that. I'd prefer a permanent revocation motion.
So it has been moved and seconded for a
If I could just, if I could come in just for a moment, since we're changing the motion, and discussion has ensued. I need to ask if any board member at all objects to the change in the motion to amend. And I don't hear any. I need to ask if any board member objects to the motion. Pardon me, Dr. Feibel wants to change his motion from a non-permanent revocation to a permanent revocation. He can do that as long as no board member objects. If one board member objects, we need to leave that motion the way it is and vote on it as it is. So does any board member object to the change in Dr. Feibel's motion to amend? And hearing no objection, we can say that the motion before the board now is to amend so that it will be a permanent revocation.
Thank you.
That's what the board needs to vote on.
So we'll go ahead with a roll call. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Dr. Gaccaloni,
Yes.
Dr. Soin,
No.
Dr. Schonstein,
No.
Dr. Reddy,
No.
Dr. Johnson,
No.
Dr. Cacarella,
Yes.
Mr. Konadakis,
Yes.
Ms. Montgomery,
No.
Dr. Feibel,
Yes.
and Dr. Bechtel, I need to abstain on this case. Ben, do we have a final count?
Yes, that was 5 votes against and 4 votes in favor and 3 abstentions. The motion to amend does not pass. The original proposed order is still before the board.
Okay. So the proposed amendment fails. Dr. Feibel.
I have one more question, logistically. Is it possible to put to reprimand and put a practice plan in place or something along those lines, some guardrails? I don't know what they would be.
Kim, could you comment on that?
Sure. So typically when you do a practice plan, she is currently under probation. So she is under probation. I can look and see if there's currently a practice plan. I think you might be able to add it to that. It's just a little complicated. So let me take a quick look at her current order.
You know, Kim,
I
before
would think you would be able to amend it, if you will, a sentence by simply saying a reprimand with additional requirements as part of her probation X. I don't see where there would be any problem with that, Kim.
Well, I think you can do. I do think you can do that. I just wanted to see what the order actually was, just quickly.
Kim, before we go, can I make a proposal that we do a non-permanent revocation? Because honestly, this is going to get to be so complicated and involved. The non-permanent revocation gives her an option to present back, try to get in. If we're cool with what she's proposing, let's go. But this whole creating another practice plan over the ones we've got, and I just don't see the value in this, quite honestly. So I would propose a non-permanent revocation like Dr. Feibel did beginning of this process, and see if we can get that through before we start this intricate process of putting together this practice plan.
I don't know. I assume a practice plan requires the doctor that's being monitored to pay something. So I think we have to take that into account as this doctor is winding down her practice. I also want to say, just a comment, as we perhaps are considering a non-permanent revocation, and respond to Dr. Feibel. I mean, no disrespect when I say I have been on these DEA, I've been on these kind of raids. They are intended to shock and awe. They come in oftentimes with overwhelming force. Remember where what we're trying to deal with here. We have a substance abuse opiate issue top of mind until the COVID thing hit us. And so you've got an imperative by the courts, by the governor, by every county commissioner and health department and any drug abuse treatment centers. This has got to be dealt with. You've got DEA with a doctor that it sounds from the record has no consistency or understanding about how to deal with those who are addicted and not handling it appropriately. You've got a person who has a mental illness history and treatment. You've got somebody who is trying to deal with life in a way that doesn't seem to have been able to organize it in a way. So you've got all those things going on at one time. And so what you're proposing with a medical a practice plan makes it even more difficult than if we took it back and settled the case or did something other than that, or took a definitive and took away the license. I'm not for revocation, but either way, we're going to be dealing, if we don't get a settlement or a revocation of license, we're going to keep dealing with this. And I don't mean to relitigate the issue, but I do want to clarify that, in fairness, there are rationales in which somebody can be shocked into when you're not surprised. I mean, I think that's part of the reason we don't allow our investigators to have guns, is that you've got a group of armed people. They probably came in with looking very menacing and in their specialized combat clothing, etc. And it's meant to shock and awe. They don't. So I just wanted to clarify that for you, Dr. Feibel. There are rationales in which somebody may, in the excitement of the moment, I think, say, "Oh, look, I don't really want to do this anymore anyway. You can have the DEA license."
Yeah, the last thing. Oh, sorry, I thought you were
Dr. Feibel?
I'm sorry, if I could clarify just real quickly, Mr. Giacalone, were you making a motion earlier to amend to a non-permanent revocation, or are you just kind of bringing it up for discussion?
I'd like to make a motion, see if it gets through. If it doesn't, we'll go with the practice.
If we can have a second to that before discussion ensues.
A second.
Second,
Second from Dr. Caccarella.
Thank you so much. Apologize for the interruption.
Dr. Feibel?
Yeah, I hate to keep talking so much, but Betty, what you said may be true, and I appreciate sorry, Miss Montgomery, and may be true, and and I appreciate the perspective. Everything you're saying to me is that you're describing her situation is somebody I don't want practicing on the public, and you're saying let's remand it back to the hearing examiner so that she doesn't practice on the public. That's our duty, to take her out of practice from the public. And everything you're describing is a person who can't handle practicing on the public, in my opinion, and somebody I wouldn't want practicing on the public. So I support the revocation, the permanent revocation. I support something more than a reprimand that doesn't do anything to protect the public from what you're describing.
You know, one last comment, put this to that. I guess my question to everybody here is, I think Dr. Feibel said it perfectly, protect the public. Would you feel comfortable having this practitioner handle your family and friends? If the answer is yes, then don't vote for revocation. If the answer is no, I think you need to vote for revocation. That's it. Thank you.
So we have a motion on the floor, which has been seconded on non-permanent revocation. And so I'd like to take a roll call. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Caccarella?
Yes.
Dr. Soin?
Yes.
Dr. Schonstein? Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Caccarella?
yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
No.
Dr. Feibel,
Yes.
and Dr. Bechtel abstain. Benton, could you give us a count on that?
I missed Dr. Schottenstein's vote. What was your vote on that, Dr. Schottenstein? I believe you're muted, Dr. Schottenstein.
I'm so sorry. It was yes.
Thank you very much. That is 8 votes in favor and 1 against with 3 abstentions. The motion to amend passes.
So the amendment has passed out for non-permanent revocation. Well, right now we'll want to take a roll call. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Flynn? I'll need another motion on that.
Move.
Second.
Johnson. Second.
Johnson, second. Roll call. Dr. Rothermill,
Abstain.
Dr. Safran,
Abstain.
Mr. Gacaloni,
Yes.
Dr. Soin,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella, Mr. Ganadakis,
Yes.
Ms. Montgomery,
No.
Dr. Feibel,
Yes.
and Dr. Bechtel abstain.
I'm sorry, Dr. Corporala, what was your vote again? I think you were muted.
Yes.
Thank you very much.
Sorry.
Thank you.
And the vote is the same as before. It's 8 in favor, 1 against with 3 abstentions, and therefore it is approved as amended.
Thank you. Please turn to the matter of Joseph Michael Francesi, MD. No objections have been filed. Ms. Lee was the hearing examiner. Request to address the board has been filed in the behalf of Dr. Francesi. 5 minutes will be allowed for the address. You'd like to go ahead, Doctor?
This is Michael Lyon on behalf of the doctor, if I may. First, I want to thank the board for letting me address you. Secondly, in this era of incivility, I want to thank Ms. Snyder, who demonstrated nothing but professionalism and dignity and respect to me and my client during this process. I'm very grateful for that. As Dr. Feibel says in the previous discussion, the mission of the board is public safety. How do you go about that? At the end of the hearing, Ms. Lee, our hearing officer, and I quote her, she says, "It is possible he has seen the errors of his ways," unquote. He, of course, being my client. The question is twofold here, and it's this. Are the structures put in place or suggested by, recommended by hearing officer Lee fulfill 2 components? Number 1, will it give my client the opportunity to not only make it possible to see his error of his ways, but probable? And number 2, in doing so, will, with the board's assistance and the structures in place, allow him to become the physician that we would all like him to become? My client at the hearing said at page 216 of the transcript, quote, "But at the end of the day, these are things that I did. I acknowledge that I did them. I own them. And I love practicing medicine, and I just hope that my mistakes don't preclude me from doing that forever," unquote. And that's nice language, and those are nice words. The question for the board is always in these cases is, how can you be assured in any way that this physician will learn from his mistake and move on in the practice of medicine, be the physician that you want him to be, and to protect the public from the mistakes he made? I submit that Ms. Lee set forth, and I'm not going to delineate them, they're in her recommendations, several safeguards, whether it be education, courses, monitoring, permanently restricting him from Schedule II prescribing, having a mentor, all these put in place for this young physician to hopefully change that possible to probable and certain in terms of learning his mistakes and incorporating them into the practice of medicine. I think that Ms. Snyder will be addressing you shortly, and I think during the hearing she expressed, and I don't want to upstage her in any way, but I think she feels that a 2-year suspension with those structures are reasonable and appropriate to fulfill your mission. And your mission, as you all know better than I, is, quote, to protect and enhance the health and safety of the public through effective medical regulation, unquote. And your mission is fulfilled, I think, by these structures put in place. And let's face it, I love using baseball analogies. My client stands with an 0-2 count here. One more strike, he's out. He doesn't get another swing at it here, and he knows it, and I think the board knows it. And all I ask is that you adopt the recommendations of Ms. Lee and let my doctor prove to all of us that it's not just possible that he's learned his ways, but it's probable, and he will go on to be the physician we want him to be. Thank you.
Does the Attorney General wish to respond?
I do. Thank you. Dr. Bechtel, members of the board, good morning. As you know from reviewing the record, Dr. Franzese is a board-certified OBGYN who lives in the Cincinnati area. He's here today because he admittedly accepted a small amount of narcotic medication from 2 of his patients who were also employees of the medical practice where he worked. He also had a sexual relationship with one of them. As you know, he was cited for sexual misconduct and for acts constituting felonies in the course of practice for accepting the drugs. He went to the Ridge for a chemical impairment evaluation and was found not to be impaired. So this is not an allegation of impairment in this site. Dr. Franzese was also cited for sexual misconduct for some sexual banter that he had with a patient while she was having a procedure. I do support the report and recommendation. I believe that Dr. Franzese has accepted responsibility for his misconduct. I don't believe that the 2 patients volunteered the medication. I just don't believe that, but I do believe that this process has, I think, awakened something in Dr. Franzese. You know, it's clear from the issues that he had no respect for the law or appropriate professional boundaries. He also appeared to have no respect for the power and influence that one has as a physician. To say that he didn't show the maturity that you would expect and demand of a young physician is frankly an understatement. That's why I think a 2-year suspension, which is a significant penalty, is appropriate in this case. I think that that will give him the time he needs to reflect, grow up a little bit, take all of the appropriate recommended classes that Ms. Lee set forth in her report and recommendation, and understand that being a physician is a great responsibility, and that, you know, he can't act like a kid in a candy shop, which I think he was a little bit. But I think that the report and recommendation is appropriate, and I believe that he does deserve another chance to prove to the board that he's up to being a physician. Thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Franzese?
So Dr. Schottenstein.
Dr. Schottenstein, okay. And do I have a second?
A second, Dr. Tyrell.
We have a motion and a second, and now I'll entertain discussion on the matter. Ms. Montgomery?
I just have a couple questions. part of the R&R was a permanent limitation of having chaperone. And what does that do going forward to his license? If he were to be licensed in another state, I assume that would cause a problem. I curious. And second of, I wasn't clear, when is the earliest that he can practice? Since we have no less than a 2-year suspension and probation for 3 years, when is the earliest he can practice? 2 years? Is that the proper answer?
Yeah.
Yes. That is correct.
And what about the chaperone question?
Ms. Anderson, could you come in?
Sure. Well, if you approve the order as proposed, there would be 2 permanent limitations and restrictions. They would be permanent. Those, those would continue even after the probation was completed. With respect to how that is impacted in other states, I can't definitively give you an answer on that, but I would tell you that this matter would be reported to the National Practitioner Data Bank as a disciplinary matter, and to other states through the Federation of State Medical Boards. So it would be a disciplinary matter that would be reported.
Thank you.
Thank you. Any other discussion? Dr. Schonstein?
Hi, thank you. So, this is a case of mitigation. The doctor has acknowledged that he engaged in the alleged behavior. It's behavior that brings disrepute upon the medical profession and has potentially toxic effects on coworkers and patients. So in a case like this, I contemplate mitigating and aggravating factors. In mitigation, there's no prior disciplinary record, and he engaged in counseling after being referred by his employer. I'm also mindful that he's a relatively young man and has only been out of training for, I want to say, 4 or 5 years. There are several aggravating factors. I think he had a dishonest and selfish motive regarding his behavior. I see a pattern of misconduct, multiple violations. I think he was at times evasive in his testimony when he was asked about his behavior, and it did, for me, call into question how much responsibility he was taking for it. There was an adverse impact of his misconduct on others. Patients and coworkers were in vulnerable positions regarding the behavior, and one of the coworkers testified to her fear of speaking up about it. I think the behavior was willful and reckless. I think he used his position of trust and his license to violate boundaries and engage in bad behavior. I think it's conceivable that the behavior recurs. Given the multitude of transgressions, I think the length of the suspension and the restrictions on the license are fair. He's a relatively young man, and I also would like to give him a chance to do better. I think it is too soon to say that he cannot be remediated, and so although I considered it, I think a permanent revocation of the license is premature. Additionally, I think the doctor would benefit from a course on controlling anger and communicating appropriately in the medical practice environment. So I would amend the order to include a disruptive physician behavior course. I think the doctor would benefit from it.
Second.
Dr. Feibel?
I second that motion.
Any further discussion? So we have, yes, Mr. Caccoloni?
I would agree, Dr. Schonstein. The one comment I keep hearing is a young physician. This is an adult, okay? I mean, I hate to say this, but I said, this young physician is in his 30s, okay? Since when did that become young? Is 30 the new 16? Because that's the way the activity was here. So it's inappropriate and it should be addressed. So I'm sorry, I'm tired of hearing the young physician. It's an adult and he should know better. End of discussion.
Can I make just a quick clarification to make sure that I understand the amendment? It would be to add the disruptive physician course to the conditions for reinstatement or restoration with the other courses. Is that correct?
That's correct. Thank you.
Thank you.
Yes, I think a 2-year suspension is appropriate. He split prescriptions for controlled substances that he wrote to employees in his office, had sexual contact with one of his patients and employees. And I was really disturbed about his, inappropriate behavior in regards to the dating app with a patient that was undergoing a procedure who was on medication. Very concerned about the professionalism in that situation. So I think that the 2-year suspension is clearly appropriate. Dr. Schonstein, would you like to go ahead and formally make your motion?
Oh, yes, if you'd be so kind. I think I motioned that. I think Dr. Feibel seconded, if I recall correctly.
Okay.
That is correct.
Okay. So I thought we would go ahead now and vote on the on Dr. Schottenstein's proposed amendment. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Caccoloni?
Yes.
Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Dr. Johnson?
I'm recusing myself.
Dr. Caccarella?
Yes.
Mr. Gonadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Reddy?
Yes.
And Dr. Bechtel, yes. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Franzese? Dr. Rothermel?
Abstain.
Sorry, forgive me, you need the motion. So I'll move. Dr. Schottenstein.
Okay. Second.
I'm sorry, who seconded that?
Bible.
Thank you very much.
Roll call, Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Caccoloni?
Yes.
Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Dr. Johnson?
Recuse.
Dr. Caccarella? Is that a yes? Okay.
Yes. Sorry.
Mr. Gonadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Reddy?
Yes.
And Dr. Bechtel, yes. I'd like to please turn the matter of Dr. Edgemund Sharma, MD. No objections have been filed. Ms. Shemansky was a hearing examiner. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Sharma?
So moved, Dr. Schottenstein.
Okay. Dr. Caccarella, and who? Second?
I think Dr. Schottenstein moved.
Sorry, I'll second.
Okay, thank you. Second. Okay.
Whichever.
Okay. Now I'll entertain discussion in the matter of Dr. Sharma. Is there any discussion? Ms. Montgomery?
Yes, it's just a long time coming to us. I think it's 5 years since it's come to us. And so I would have to say to you that in an ideal world, had this come to us in a more timely fashion, I would agree with everything that was recommended by the hearing officer. But at this point, making this particular doctor take another course, he's already taken the course in a more timely fashion when in other states, and requiring probation at this point for something that happened it's rather like I used this metaphor once before, where what we've done is we're taking the batter's up and taking a swing, but the ball is already in the catcher's mitt. If this were timely, I would say, hey, okay, but I would say that it makes no sense to waste our time on a probation for him for 5 years ago on a moment in time that he self-regulated himself, albeit I'm not at all diminishing, he shouldn't have done what he did. moment in time from February 3rd to February 6th, 5 years ago, and a couple of phone calls. And there's no reason for him to take another course. He's already taken a course in a more timely fashion. So I would like to amend the proposal to reprimand if it's necessary, if we all believe he's needed to be reprimanded, and a fine, but not to require him to take a new course, not to require him to be on probation.
I would second that.
Any further discussion? Dr. Schonstein.
Thank you. So I think that patient A conceptualized her relationship with the doctor as transactional. In the context of her sexual communications, she expected that he would give her a favorable rating on her exam. When he did not, she felt duped and betrayed and used. And when one experiences those feelings, one turns one's anger onto the perceived responsible party. That is why she responded so vigorously with calls to not one but 2 police departments regarding the doctor's behavior. The boundary violation transformed her reaction to the medical report from one of disappointment to one of anger. You know, it's the paradox inherent in sexual misconduct between a doctor and a patient. Because the patient may seem inclined toward the sexual activity, the doctor perceives that she's gratified by it. But in actuality, patients walk away from those encounters feeling minimized as human beings. It's been 6 years since this incident took place. I guarantee you she's still thinking about it and still angry about it. That said, there's been no other inappropriate encounters with patients that we know of. The doctor has done a lot of remedial work to address his boundary issues, and the behavior is remote. You know, and he's gotten good feedback from his caregivers regarding the progress he's made. So I agree with the proposed amendment.
Any further discussion? So I thought we'd go ahead with a roll call on the amendments for reprimand rather than probation. Dr. Rothermill?
I'm sorry, it's reprimand, fine, but no course and no probation.
Okay, thank you. Thank you for clarifying that. Dr. Rothermill?
Abstain.
Dr. Safran?
Abstain.
Dr. Gacaloni?
Yes.
Dr. Soin?
Yes.
Dr. Schonstein?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Thank you. Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Reddy?
Yes.
And Dr. Bechtel, yes. So so do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Sharma? Dr. Rothermill?
Abstain.
Dr. Safran?
Abstain.
I'm sorry, could we get actually a motion and a second before the roll call, please?
Okay.
So moved.
Second.
Dr. Johnson, second. Okay.
Thank you so much.
Okay, thank you. Thank you, Ben. Dr. Rothermill?
Abstain.
Dr. Safran?
Abstain.
Mr. Gacaloni?
Yes.
Dr. Soin?
Yes.
Dr. Schonstein?
Yes.
Dr. Cacarella?
Yes.
Mr. Ganadakis?
Yes.
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Reddy?
Yes.
And Dr. Bechtel, yes. Please turn to the matter of Onyenyechi Rose Hirado, MD. Objections have been filed and were previously distributed to board members. Mr. Porter was a hearing examiner. A request to address the board has been filed on behalf of Dr. Hirado. 5 minutes will be allowed in that address.
Thank you, sir. Thank you, Mr. President, members of the board. My name is John Izzo. I am an attorney with Graff and McGovern here in Columbus, and we are representing Dr. Hirado post-hearing in this matter. Dr. Hirado is online, and she'd like to address the board shortly after I finish addressing the board. First, though, I do want to review a couple of items that I placed in the objections. We are here today because of Dr. Aradu's prior action before the board, but we do not want to retry that case. I just want to point out that the prior board action occurred because Dr. Aradu was utilizing Suboxone for the treatment of addiction in violation of the 100 patient limit.
That's my favorite.
I'm sorry? Can you hear me?
Yes, yes.
Yes, I can hear you just fine. Well, I'm not sure what the audio was, but you can continue with your address.
Okay, thank you. This is referred to on page 21 of the hearing examiner's report and recommendation. Dr. Aradu was not inappropriately prescribing. She was never found or charged with inappropriately prescribing. She properly prescribed Suboxone to her patients, but her problem was that she had more than 100 patients. This was a technical violation, but a violation nonetheless, but one that had nothing to do with the care that she provided to these patients. Dr. Aradu's prior violation is very different than the reason this board used to deny Dr. John Allen Ross's request for a certificate to recommend. Dr. Ross ran a sloppy ship, it appears, from looking over the documents in that case. In addition to allowing 2 nurses to perform eye lipo laser treatments, he left blank pre-signed scripts with his office staff. This is clearly inappropriate. And by doing so, of course, he had no idea who would get what drugs, despite the fact that it was all under his name. As a result, Dr. Ross entered into a settlement agreement admitting that he departed from or failed to conform to minimal standards of care. And it was that violation that was used as a basis to deny him his certificate to recommend, because it was shown that his past action had to do with inappropriate prescribing. Dr. Aradu was not reckless in her use of her prescription pad. Dr. Aradu was not found to have departed from minimal standards of care. Dr. Aradu was not found to have inappropriately prescribed Suboxone. Dr. Aradu's bad act was that she prescribed the Suboxone to more than 100 patients, not that she inappropriately prescribed Suboxone to a patient, as the hearing examiner suggests in his report and recommendation. As a result, we don't believe the prior disciplinary action involved inappropriate prescribing, and therefore Dr. Aradu should be awarded her certificate to recommend. And I'd like to turn the balance of my time over to Dr. Aradu. Thank you.
Thank you very much for this opportunity for me to address you before you vote on my case. Let me highlight why I need a CTR, the good that it can do for my patients, and the reasons why you should reject Mr. Porter's recommendation. I work as an addiction specialist, and 100% of my time is spent with patients dealing with substance use disorder. It is a known fact that these are very complex populations. For this reason, I have always followed proven best practices to ensure their safety and well-being. In 2016, based on new knowledge, this medical board approved medical marijuana for the management of specific medical conditions. Some of the approved diagnoses are very common among my patient population. So I decided to apply for a CTR so I can offer them that therapeutic option. For instance, 76% of my IV drug users are hepatitis C positive. 13% have HIV. 10% have chronic intractable pain. 6.6% have cancer and its attendant cachexia. Between 21 and 43% of PTSD patients also have substance use as comorbidity. Giving them access to medical marijuana as a continuum of care may be the difference between them getting a job or spending time in jail or losing custody of their kids. Since I already know their history better than most other providers, having a CTR will give them more comprehensive care at no extra cost. I will feel inadequate as a provider if I cannot offer my patients a treatment option that has been found clinically effective for what ails them. If I am denied these two, it will affect my professional growth, and my patients will be the worse for it. I am therefore pleading with you to approve my CTR application especially since my previous administrative sanction has nothing to do with the quality of care I provided and has nothing to do with inappropriate prescribing. Thank you.
I'm sorry, Doctor. I was about to say your time has expired, but you already concluded. Thank you very much.
Thank you.
Does the Assistant Attorney General wish to respond?
I do. Thank you, Mr. President. Good morning, members of the medical board. As you know, this is a proposed non-disciplinary denial of an application for a certificate to recommend medical marijuana that Dr. Uradu applied for in August of 2019. The board was given authority by the legislature to promulgate rules for applicants for this certificate to recommend. The board did so, going through the JCAR process, and those rules were promulgated without objection. I would point out the state at hearing did not have any opportunity to respond to any of the arguments that were brought forth after the hearing in the objections filed by Mr. Izzo. However, I would point out again, this rule went through the JCAR process. It was approved unanimously without objection. In addition, the argument that somehow the language of the rule doesn't fit what occurred in Dr. Uradu's past, I think the board should flatly reject. They seem to focus on this word, inappropriate prescribing. Well, the rule also says it deals with personally furnishing, dispensing, diverting, administering, or supplying any controlled substance. So those violations that the board found against Dr. Uradu in a disciplinary proceeding in 2016, that included a misdemeanor in the course of practice for exceeding the number of patients she could prescribe to under the DEA data waiver, and also surrendering that particular waiver to the DEA, I think clearly fall under the board's rule. So as this board did in the matter of Dr. Ross, where this board had a similar case where they denied the application, I think the report and recommendation here is appropriate analysis, and it should be upheld by this board. And I recommend that you adopt it. Thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Uradu?
So moved.
So moved.
Johnson, and second by Dr. Johnson. Any discussion? First of all, I think with a certificate to recommend, the rules are pretty clear that if a health provider has been subject to disciplinary action by any licensing board due to inappropriate prescribing or administration. So, we look at what happened with the Suboxone situation, surpassed the limit of patients that she was allowed to manage. She clearly showed a violation of administering in that situation and was disciplined for that action. So I think the action of denial is appropriate. Dr. Swain?
Yes, thank you. I just want to agree with you rather strongly that denying this is important. But there's a couple of things I wanted to mention based on some defense objections that came up, specifically regarding whether or not this was inappropriate or whether or not standard of care was followed, et cetera. And I want to make the claim and the case that, this was pretty inappropriate on many levels. I mean, if you just look at the prescribing pattern, July 15, 2014, 111 prescriptions, the limit's 100, and you can say, well, that's pretty close. But then you go July 15th, it's 152, August 15th, 166, August 31st, 185. 185, I mean, you're blowing past that 100 requirement by a lot, not by 10%, not by 20%. You're almost blowing by it by 200%, basically. That is a huge, huge issue. And that, if you are a trained and certified person doing addiction medicine, that is below standard of care. And why do I say that? Because there's a law that defines what standard of care is, and you've broken it. Not only that, part of the training to be an addiction specialist, you have to do these quarterly audits, you have to do census counts, you have to follow all of these things. Clearly, she didn't do that. In addition to not prescribing properly, not doing those audits properly, not following the census properly is another deviation of standard of care. But there's one other thing I want to mention that makes me uncomfortable, and that was her testimony today. I'm paraphrasing what she said to an extent, but at one point when she was talking, she said, I'd like to offer things that have been proven clinically effective to my patients. Now, one thing I want to mention about medical marijuana is a fact that's been openly disclosed and discussed many times, is that the clinical efficacy of medical marijuana has not been established in humans. There's no clinical trials, there's no evidence, it's anecdotal, and we are open and upfront with that. When you prescribe it to patients, the only thing that actually has some sense of human data is chemotherapy-induced nausea, and even that is a very small cohort of patients. My concern with this statement is if that's how she feels that this is somehow clinically effective based on evidence that I haven't seen, and I'm on the Medical Marijuana Commission, which is a separate commission on the board. I review a lot of data, and it's just not there for these things. And if she already has a pattern of breaking the rules and over-prescribing, that makes me even more uncomfortable. And so I strongly feel that we should deny the certificate to recommend.
Dr. Schonstein?
Thank you so much. So I'm respectful of the comments that have been made thus far, and I agree with them. I'm also respectful of Dr. Uradu's motivations and intentions regarding her desire to obtain a certificate to recommend medical marijuana. And like defense counsel, really the only matter I'm contemplating today is whether the board has leeway to grant her a certificate to recommend medical marijuana under our rule 4731-3202. I also am not inclined to relitigate the events surrounding the previous board order. And so regrettably, the rule is explicit regarding the prohibition of a certificate to recommend in licensees with a history of board action related in whole or in part to inappropriate prescribing. And so I also was mindful of the objections of defense counsel and mindful of defense counsel's concern about the word inappropriate as it's used in our rule. And so I would also say, though, that defense counsel made the point in his objections that neither Chapter 4731 nor the rules promulgated thereunder define what inappropriate means. And so respectfully, I don't know that both things can be true in the sense that if the word inappropriate is not explicitly defined, I don't know how you point a finger at the hearing examiner and say that he did not properly interpret it. I think what makes this challenging is not the word inappropriate, but the phrase in whole or in part, because that phrase casts a wide net in terms of a history of prescribing concerns. And defense counsel was kind enough to include the CSI documents, and we were able to review them. I think the documents demonstrate that there was a great deal of stakeholder input that went into the rulemaking process. The CSI document notes that the board consulted with the Ohio Medical Marijuana Advisory Committee, a panel of physicians, and a group of individuals representing medical marijuana patient groups. There do not appear to be comments received during the process supporting defense counsel concerns regarding the eligibility rule 4731-3202, other than some comments that were made about CME requirements. So in fact, the CSI document states, and I quote, "The state has a compelling interest in promoting safe and temperate use of medical marijuana while avoiding risk associated with the diversion and theft of medical marijuana," close quote. So to promote that interest and to minimize those risks, we have strict eligibility requirements to grant a certificate to recommend medical marijuana. So contrary to defense counsel concerns and supporting what Mr. Wilcox had to say, I think that provides the rational basis for the rule. And so finally, I would just like to respond to a point raised by Dr. Uradu in her testimony before the board during the hearing. She referenced the fact that the board has wide latitude and discretion in matters that come before it, and that there is in fact no criminal offense that automatically bars a licensee from obtaining a license. But there is a difference between the fact that no criminal offenses automatically bar an applicant from obtaining a medical license and the fact that there are eligibility requirements in our rule for obtaining a certificate to recommend. The board is an administrative body. We cannot abuse our discretion by picking and choosing when we follow the dictates of a rule. Otherwise, it's not a rule, it's a guideline. And a rule is, in fact, administrative law. We are bound by it. So when a rule is explicit, as 4731-3202 is, we cannot ignore it or behave in a way that contradicts it in order to accommodate a licensee with whom we may sympathize. We have an obligation to follow the law and our own rules. So I agree with the proposed order to deny the certificate to recommend.
Any other discussion? There appears to be
Mr.
Giacolone.
Mr. Giacolone. Yes.
Yeah, just a couple of points. The defense counsel wants to say they don't want to relitigate the case, but that's exactly what they're doing. And they cite to the hearing examiner's testimony, which the board order does not agree with. So yes, we've started to relitigate the case. Second, he talks about a sloppy ship in the prior case. Sloppy ship would be this one, where the prescribing or the administration of Suboxone was out of control. So again, on both points, there's a disconnect between what defense counsel is saying and what the board had decided at the time in that case. And lastly, you know, as pointed out, I have concerns. I mean, one of the rationales I think that Dr. Radu's cited for the overprescribing Suboxone was for the welfare of patients. Take that to the extreme. Well, if the medical marijuana is used outside of the scope of what's intended by law, then that could be construed for the welfare of patients. So again, we're going off tilt. So again, looking strictly at the case, however, it's a violation. Therefore, as Dr. Schottenstein and others have articulated, she is not entitled to the certificate. Thank you.
Any more discussion? In light of the fact there's no amendment, I'd like to have a roll call to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Aradu. I'll take a roll call now. Dr. Rothermel? Dr. Safran?
Abstain.
Dr. Giacolone?
I think Dr. Feibel wanted to say something, but I'm moving.
Oh, no, I thought we needed a motion. I'm sorry.
Okay, sorry.
Motion.
Yes.
Dr. Giacolone?
Well,
Mr.
why don't we formally have a motion and then have it seconded, just to be sure that we're voting on it properly.
Okay.
They're voting on the motion that was made prior to discussion that was made by Dr. Schottenstein and seconded by Dr. Johnson. So another motion isn't required.
Thank you.
So then we go ahead with the regular roll call. Is that correct? Yes.
Yes, that is correct. Thank you.
That's what I thought. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Giacolone?
Yes.
Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Mr. Gonadakis?
Abstain.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Reddy?
Yes.
And Dr. Bechtel, yes. I thought we would move next to the proposed findings and proposed orders. And the only matter is the board issued a notice of opportunity for hearing, and no timely requests for hearing were received. The matters were reviewed by a hearing examiner who prepared the proposed findings and proposed orders, and they are now before the board for final disposition. These matters are disciplinary in nature, and therefore, secretary and supervising member cannot vote. In these matters, Dr. Rothermel served as the secretary, and Dr. Safran served as the supervising member. Please turn now to the matter of Kahanchi Bahami, MD. Do I hear a motion to find the allegations as set forth in the February 12th, 2020 notice of opportunity of hearing in the matter of Dr. Bahami Hami have been proven to be true by a preponderance of the evidence, and to adopt Ms. Szymanski's proposed findings and proposed order?
So moved.
Dr. Schonstein moved, and then second. Dr. Johnson. I now will entertain discussion concerning the matter. Is there any discussion? Ms. Montgomery.
Just one observation. I wonder why we went through 3 publications. Surely a phone call to the federal authorities would have told us where this doctor was incarcerated. So it might be something we need to look at in the future, because it's expensive and delay is, this case was delayed unnecessarily, I think. So it's just something for us to look at.
Yes. Yes. Any further discussion? I'd like to have a roll call to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter. Dr. Bahami Hani, roll call, please. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Dr. Gaccaloni. Mr. Gaccaloni.
Yes.
Dr. Soin.
Yes.
Dr. Scheinstein.
Yes.
Dr. Johnson.
Yes.
Dr. Caccarella.
Yes.
Mr. Ganadakis.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Reddy.
Yes.
And Dr. Bechtel, yes. Please turn the matter of Mohammed Raza Khan, MD. Do I hear a motion to find that the allegations as set forth in the April 8th, 2020 Notice of Opportunity for Hearing in the matter of Dr. Khan have been proven to be true by a preponderance of the evidence, and to adopt Ms. Szymanski's proposed findings and proposed orders? Do I have a motion?
So moved.
Dr. Schonstein, do I have a second?
Second, Dr. Tucker.
I will now entertain discussion concerning the matter of Dr. Khan. Is there any discussion? Appears to be no discussion. We have a roll call to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Khan. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Dr. Gaccaloni. Mr. Gaccaloni. Dr. Soin.
Yes.
Dr. Schonstein.
Yes.
Dr. Johnson.
Yes.
Dr. Caccarella.
Yes.
Mr. Ganadakis.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Reddy.
Yes.
And Dr. Bechtel, yes. All right, I'm sorry. On Dr. Khan, I'll have to actually abstain on this case. Thank you.
Yes.
Please turn the matter of John W. Kim, MD, to a motion to find that the allegations as set forth in the July 28, 2020 Notice of Opportunity for a Hearing in the matter of Dr. Kim has been proven to be true by a preponderance of the evidence, and to adopt Ms. Lee's proposed findings and proposed order. Do I have a motion?
So moved, Dr. Johnson.
Dr. Johnson, and second by Dr. Schottenstein. I will now entertain discussion in the matter of Dr. Kim. Is there any discussion? Not seeing any discussion. Roll call to vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Kim. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Mr. Gaccaloni.
Yes.
Dr. Soin.
Yes.
Dr. Schottenstein.
Yes.
Dr. Johnson.
Yes.
Dr. Caccarella.
Yes.
Mr. Ganadakis.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Reddy.
Yes.
And Dr. Bechtel, yes. Please turn to the matter of Rosie McKnight. Do I hear a motion to find that the allegations as set forth in the May 13th, 2020 Notice of Opportunity for Hearings in the matter of Ms. McKnight have been proven to be true by a preponderance of the evidence and to adopt Ms. Lee's proposed findings and proposed order. Do I have a motion?
So moved, Dr. Johnson.
Second, Dr. Schottenstein.
Cockrell, second. Thank you. And I'll now entertain discussion in the matter of Ms. McKnight. Is there any discussion? Ms. Montgomery.
Just one question. If Kim may need to insert in the document that on July 30th, 2019, there's an application for the massage therapy license. I don't know if that's if that is something. If it weren't in there, it would be a problem legally. So maybe we just have to amend that a little bit. But it's just an observation that's it's missing in the. I believe it's missing in the process. So it's just a small amendment that I think can be done without a formal.
Ms. Anderson.
Can you help me with that, Ms. Montgomery? I'm not sure I'm following.
On page 7, you're missing the recitation that there was an application for a license on July 30th, 2019. I don't know if that's fatal or not. I'm just asking you if it's not fatal, then don't worry about it. But I think you have to say that they applied before you talk about what you're going to do about it. So it's just a missing. I think it's missing in the document.
I was looking, if you look at the first or the second full paragraph at the top of page 6, under little paragraph 1, it says on or about July 30th, 2019, you submitted an application. Do you think that satisfies?
I don't want to delay everybody. If you think that's sufficient, that's fine.
Okay. I truly just, I'm not sure I understand. So, but if you think there's something that we need to add, then I think we should do that. If there's something that makes it more clear, but I'm having a hard time following it. That's all.
You won't be the first to have a hard time following me. So, no, that's fine.
No, it's on me. I just want to make sure I understand, and I'm not sure I do. So.
Okay. Talk offline then. If you think what you have now is sufficient, go for it.
Well, I guess what I would say is I'm not sure.
I'm going to remove my comments. I don't think it's worth delaying the board on this. So if you feel it's sufficient, so.
Any further discussion? I'd like to have a roll call now to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Ms. McKnight. Take a roll call now. Dr. Rothermill.
Abstain.
Dr. Safran.
Abstain.
Mr. Gaccaloni. Dr. Soin.
Yes.
Dr. Schottenstein.
Yes.
Dr. Johnson.
Yes.
Dr. Kakarala.
Yes.
Mr. Ganadakis.
Yep.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Reddy.
Yes.
And Dr. Bechtel, yes. Please turn the matter of Monica Lynn Richardson. Do I hear a motion to find that the allegations set forth in the May 13th, 2020 Notice of Opportunity for Hearing in the matter of Ms. Richardson has been proven to be true by a preponderance of the evidence and to adopt Ms. Lee's proposed findings and proposed orders? Do I have a motion?
So moved, Dr. Cockrell.
Second?
Second.
Dr. Schottenstein, thank you. And I'll now entertain this discussion concerning the matter of Ms. Richardson. Is there any discussion? Seeing no discussion, I'd like a roll call to approve and confirm the proposed findings of fact, conclusions, and order is presented in the matter of Ms. Richardson. We'll take a roll call. Dr. Rothermill,
Abstain.
Dr. Safran,
Abstain.
Mr. Gacaloni,
Yes.
Dr. Soin,
Yes.
Dr. Schonstein,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Gonadakis,
Yes.
Ms. Montgomery. Ms. Montgomery? Okay, thank you. The answer is yes. Dr. Feibel,
Yes.
Dr. Reddy,
Yes.
and Dr. Bechtel, yes. Please turn to the matter of Stevens triplet DO. Do I hear a motion to find that the allegations as set forth in the June 10th, 2020 Notice of Opportunity for Hearing in the matter of Dr. Triplett has been proven to be true by a preponderance of the evidence and to adopt Ms. Lee's proposed findings and proposed order? So I have a motion, please.
Move.
Ms. Montgomery, okay, second. It was second.
Dr. Cockrell.
I will now entertain discussion concerning the matter of Dr. Triplett. Is there any discussion before the board? Seeing no discussion, roll call to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Triplett. We'll now take a roll call. Dr. Rothermill,
Abstain.
Dr. Safran,
Abstain.
Mr. Gacaloni,
Yes.
Dr. Soin,
Yes.
Dr. Schonstein,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Gonadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Reddy,
Yes.
and Dr. Bechtel, yes. I'm sorry, Ben, I'll need to actually recuse myself or abstain on that vote also on Triplett. Thank you, sir.
Yeah, thank you very much.
And now we'll move to findings, orders, and journal entries. In the following matters, the board issued notices of opportunity for hearing, and documentation of service was received for each. There were no timely requests for hearings filed, and more than 30 days have elapsed since the mailing of the notices. These matters are therefore before the board for final deposition, and the matters are non-disciplinary in nature, and therefore all board members may vote. We'll now turn to Amy Mamajek Fu, RCP, and again, all members can vote. On June 10th, 2020, the board authorized an issuance of notice of opportunity for hearing to Amy Mamajek Fu, RCP, informing her that the State Medical Board of Ohio proposed to approve her application for a license to practice respiratory care, provided that she take and pass the clinical stimulation examination, or CSE, due to the fact that Ms. Mamajek Fu had not engaged in active practice of respiratory care for more than 2 years. Do I hear a motion to find that the facts set forth in the June 10th, 2020 Notice of Opportunity for Hearing have been proven to be true by a preponderance of the evidence, and that the board enter an order effective immediately upon mailing, approving Ms. Mamajek Fu's application for a license to practice respiratory care in the state of Ohio, provided that she takes and passes the CSC within 1 year of mailing of the Notice of Opportunity for a Hearing?
So moved.
Motion. Dr. Schonstein, motion. Okay, second.
Second.
Okay, Dr.
Second,
Safran?
Dr. Johnson.
Okay, thank you. Is there any discussion concerning the motion? I'd like to go ahead and take a roll call. Dr. Rothermill,
Yes.
Dr. Safran,
Yes.
Mr. Gacaloni,
Yes.
Dr. Soin,
Yes.
Dr. Schonstein,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Reddy,
Yes.
and Dr. Bechtel, yes. We'll now turn to the matter of Kimberly Sue Obermeyer, MT, and again, all can vote on this. On November 10th, 2020, the board authorized issuance of a notice of opportunity for hearing to Kimberly Sue Obermeyer, MT, informing her that the State Medical Board of Ohio proposed to approve her application for restoration of her license to practice massage therapy, provided that she take and pass the massage and bodywork licensing examination, the MBLEX, due to the fact that Ms. Obermeyer has not engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the November 10th, 2020 notice of opportunity for hearing has been proven to be true by a preponderance of the evidence, and that the board enter an order effective immediately upon mailing approving Ms. Obermeyer's application, provided that she takes and passes the MBLEX within 1 year of the date of mailing of the notice of opportunity for a hearing? Do I have a motion?
So moved.
Second.
Okay, second. Dr. Caccarella and Dr. Shine, is there any discussion concerning the motion? To go to a roll call then, Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Gaccaloni,
Yes.
Dr. Soin,
Yes.
Dr. Scheinstein,
Yes.
Dr. Johnson,
Yes.
Dr. Caccarella,
Yeah. Excuse me. Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Reddy,
Yes.
and Dr. Bechtel, yes. I'd like now to turn to the matter of Corey A. Pierce, MT. On November 10th, 2020, the board authorized issuance of a notice of opportunity for hearing to Corey A. Pierce, MT, informing her that the State Medical Board of Ohio proposed to approve her application for restoration of her license to practice massage therapy, provided that she take and pass the massage and bodywork licensing examination, due to the fact that Ms. Pierce has not been engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in November 10th, 2020 notice of opportunity for hearing has been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing approving Ms. Pierce's application, provided that she takes and passes the MBLEX within 1 year of the date of mailing of the notice of opportunity? Do I have a motion?
So moved.
Dr. Safran, do I have a second?
Second, Dr. Caccarella.
Any further discussion concerning this the motion? I'd like to go ahead with a roll call. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Gaccaloni,
Yes.
Dr. Soin,
Yes.
Dr. Scheinstein,
Yes.
Dr. Johnson,
Yes.
Dr. Caccarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Reddy,
Yes.
and Dr. Bechtel, yes. I thought we would go ahead and move forward with the executive session, and then maybe consider taking a break after that. I'll now entertain a motion to go into executive session to confer with the medical board's attorneys on matters of pending or imminent court action, and for the purpose of deliberating on proposed consent agreements and the exercise of the medical board's quasi-judicial capacity, and to consider the appointment, employment, dismissal, discipline, promotion, and demotion or compensation of a public employee or official. I'll need a motion.
So moved, Dr. Johnson.
Dr. Johnson, second.
Second, Dr.
Second.
Safran.
Okay, Dr. Safran. The motion has been made and seconded, and we'll now take a roll call. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Gacaloni.
Yes. Hey, Mark, quick question. Are we supposed to log off on this and then log into the executive session?
Yeah, well, after we do the roll call, then we'll log off and.
I'm sorry. Yes.
No. Dr. Soin,
Yes.
Dr. Schonstein,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarola,
Yes.
Mr. Donadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Reddy,
Yes.
and Dr. Bechtel. Yeah. So what we'll need to do now is log off and then log back
This
on.
conference is no longer being recorded.
Sorry about that, Dr. Bechtel. You can go ahead.
Okay.
Well, yeah, log off and log back on. Thank you.
You don't have to log off.